All right, we are now live and recording.
Morning, welcome to the appeals court. I am Justice Meade. With me this morning are Justices Wolohojian and Massing will be the panel for your case. Each side is entitled to 15 minutes. You needn't use all your time and we don't entertain rebuttal. With that, I'll call the case. 2020 P613, National Lumber Company versus Peter Miranda and others. Mr. Perry.
Thank you, Your Honor, and may it please the court. My name is Timothy Perry. I represent Russell Fleming and Peter Miranda, who are the two individuals who guaranteed the contract that's at issue in this case and has led to the debt that is being sought by National Lumber in this case. At the start, I know that there's a lot of pleadings and a large amount of documents that make up the record in this case. But the most important and determinative fact of this case is quite simple and clear. And that fact is that Mr. Fleming and Mr. Miranda only provided a personal guarantee of one contract in this case. And that contract is the material supply contract, which was trial exhibit number 7, which is at appendix volume 9, page 52. And it was signed in October of 2000. That contract on its face was between F&M Realty Trust II and National Lumber. Under that contract, National was to supply lumber and building materials to one site that's specifically stated on the face of the contract, which was 192 Pearl Street, Malden, Massachusetts, where
You're talking about trial exhibit 7?
Yes.
It says F&M Realty, but it doesn't have the 2. I'm on page record appendix 46. Is that correct?
No. Trial exhibit 7 was appendix volume 9, page 52. That's the original material supply contract between the parties.
Oh yes, that one does say F&M Realty. Yep.
Yeah, that's F&M Realty Trust II. That's the only material supply contract that my clients ever saw. And
what about Mr. Crotty?
Right. So
he executed contracts for materials.
Right. And so Mr. Crotty was an employee of the contractor who worked at 2 later sites that were not owned by F&M Realty Trust II. They were owned by 2 separate corporations, and they were 2 completely different sites. And that's why I think there's a tendency in this case, and I fall into it as well as anybody, to get into Mr. Crotty because he worked on sites that were 5 years later after the original contract that my clients guaranteed was this trial exhibit 7.
But if Mr. Crotty had the authority, apparent or actual, to bind F&M in these matters, he did order the materials for the projects, then F&M is bound by them as well. Yes.
Well, that's potentially true if certain steps are taken and met. Number one, the contracts would have to identify the party to be bound, which these later contracts that National drafted don't identify, as Judge Wolohojian just pointed out, don't identify F&M Realty Trust II. They identify a prior entity called F&M Realty, which didn't even exist anymore. And
can I ask you, Mr. Perry, if
Yeah.
F&M didn't believe they were bound by these contracts that Mr. Crotty signed, why did they pay for the materials? And otherwise, they ratified his conduct as acting in their behalf.
Well, that's actually not true, with all due respect, Your Honor. What happened is the corporate entities paid for all materials that were supplied to those new projects. So in 2004 and 2005, Mr. Fleming and Mr. Miranda set up corporations when they bought the new locations for the new projects. Those were distinct corporations. And when Mr. Crotty, who was employed by the contractor at the site, submitted requests for payment, those entities, they were signed by Mr. Miranda, who was a president of the new entities, but they were on checks, and those are in the record, on checks from those corporate entities. F&M Realty Trust.
Maybe I phrased it poorly. If the corporate entities ratified Mr. Crotty's conduct by manner and payment, why aren't they bound?
Well, those corporations are bound, and that's a point I make in my brief. Everybody believed that the corporate entities were bound, including National, because when those new projects under those corporate entities failed, National Lumber went after those corporate entities. They didn't initially go after F&M Realty Trust 2 or my clients who have the personal guarantees. What they did was they went after the corporate entities. And most important, when they did that, when 63 Central Place LLC went into bankruptcy, National Lumber went into bankruptcy court and filed a proof of claim against 63 Central Place LLC, saying that that entity owed the debt, not F&M Realty Trust 2.
Okay, then let's talk about the guarantee then.
Okay.
The guarantee, as I saw it, covered all transactions between F&M and National until Fleming and Miranda terminated the guarantee.
That's right. But the project, and this is why I think it's very important to go back to the contract that my clients guaranteed, and it was only that initial project. That contract.
I'm sorry to interrupt. It's the guarantee said it covered all transactions, not just one.
All transactions under that contract, because contract law is quite clear. That a guarantee. Sorry.
Mr. Perry, it might be helpful if you point us to actual language in the guarantee, because I'm looking at the actual guarantee and I don't see that it says that it's limited to the initial contract. It refers to the credit application. It refers to the entire account of the customer. It refers to the applicant on the other side of the document. That applicant is inconsistently named even on the other side of the document. So can you point specifically to the language in the guarantee?
Yes.
Okay, go ahead. I'm looking at it.
And I apologize because I have to start with the contract that's being guaranteed, because the language there is what controls.
With all due respect, I'm going to ask you to start with the guarantee, because that's what's going to control the liability of your clients. So,
okay.
So just point to me the language, because I read the first sentence in the guarantee. It says, in consideration of your extending credit to the applicant on the reverse side hereof. That's the document I'm looking at.
Right.
Okay.
And
so where is the language that says it's limited just to what you're pointing to as the supply contract Exhibit 7?
okay. So what it references down below where it says account status, and this is very important. It says open on November 14, 2000, and it references
which paragraph of the guarantee is that?
The very bottom of record appendix, page 52 there.
At the very bottom, it's referencing the accounts that my clients are guaranteeing. And those, there's one for lumber and one for windows.
So you're saying those two annotations limit what's written above?
Yes, because when there's the next trial exhibit is Exhibit 2, which is on volume 4, page 54. That's the opening of the credit account. And this is a letter from National Lumber, and those same two account numbers are what's listed in that. And they say, you have $200,000 worth of credit under those two accounts. And why I say you need to go back to the original contract is that it says essentially that I'm reading a quote from the original contract that my clients agreed to guarantee. It says, essentially, the terms of payment and collection stated in the credit agreement shall apply to all purchases under this contract. That contract was only for 192 Pearl Street, and that contract was only for those two account numbers. And so it's very.
Do you see
Sorry.
in the first sentence of the third paragraph of the guarantee? It says this agreement is intended to cover a running account or accounts by the customer.
That's right.
So how do we square that language with the argument you're making now?
Because there were two running accounts for this customer, which are listed at the bottom of that page, which was confirmed in trial exhibit number 2 by National. There were two running accounts. Those accounts ran for 2 years, and they continually turned over. So in other words, they could get credit up to $200,000 under those two accounts. They had to be paid off, and then the accounts would start running again. All in those 2 years, the condominium was made and sold, and then National was fully paid off on those accounts. All of the money that National Lumber is seeking in this case were billed under separate accounts, new account numbers that were created 5 years later at the new projects.
Were those goods sold on credit?
Yes, under the new material supply contracts that were created by National 5 years later.
What was there a credit agreement that covered those?
Just the material supply contracts that you see as trial exhibit 4 and trial exhibit 5.
Well, they say further, the parties incorporate here in the terms of a credit agreement, AKA credit application between National and purchaser, which credit agreement was previously executed and delivered by purchaser to National. And I thought, but correct me if I'm wrong, the only one is trial exhibit 8.
Right. So what happened was, it's a National's policy to have new credit agreements with every new account that's open. That's what the testimony is. And the testimony was that Mr. Prey, who works for National, went to these new job sites, and he had new credit application, which is applications for each new site, that he requested that Mr. Crotty signed when he signed these material supply contracts. And Mr. Crotty refused to sign the new credit applications because he said he didn't have authority to sign credit applications on behalf of anyone, much less my clients. So they asked for new credit applications, but they didn't get them. This just happens to be their standard form contract, so it has that language there. But the testimony was they asked for the credit applications, but Mr. Crotty refused to sign the credit applications for the later projects. So National Lumber just started supplying goods and services with the hope that these new entities were going to be successful, just like F&M Realty Trust had been successful. As it turned out, they were unsuccessful and they went into bankruptcy. When that happened, they ran into the bankruptcy court and said that those new entities, not F&M Realty 2, owed the debt. If you look at page 43 to 45 of my brief, it's very clear what happens when you go into bankruptcy court and you claim that one entity owes the debt, not another. It has preclusive res judicata effect. When you say, and they've made arguments without citation to any authority that this isn't the case, but there's clear authority that when you say in bankruptcy court under oath that 63 Central Street owes the debt for all the goods and materials that were delivered to that site, that creates res judicata, and you cannot claim in another forum like this one that F&M Realty Trust 2 and its guarantors really owe the debt.
Can you tell me what the effect of the, I take it there was a post-judgment compromise of the interest on the judgment?
There was a, oh, that's a good question. There was a long delay, as we've said in our request for involuntary dismissal. There was a long delay in the case when one of the other parties went into bankruptcy. And then there was a bankruptcy court, the Superior Court made its standard bankruptcy order, which said that National needed to file status reports, and they didn't do that for a period of 3 years. And they missed 6 required status reports that they were going to file. And so I think my memory is, and I'm sorry if I butcher this a little bit, but I think there was a concession that, you know, the interest shouldn't run at least during that period.
Right, so, and that was entered into after the judgment, am I correct? All I'm really trying to find out is, would anything that we did here, whether we affirm, what would be, would anything that we do here affect that agreement or that compromise, in your view?
No, all that we're requesting is that as a matter of law, the court look at that original material supply contract, and as a matter of, and then the guarantee on which that is based, and decide that Fleming and Miranda personally are not responsible for the later debts of these other entities. So if you denied that relief, I think the other parts of the judgment would stand. If that answers your question, I hope it does.
Yep, thank you.
Okay, thank you.
Thank you.
Mr. Cacavero.
Good morning, Your Honor. Thank you. May it please the court, Louis Cacavero for National Lumber, the appellee. I had intended to jump right into my legal arguments, but I think it makes sense to take a moment, step back, and give some context as to how accounts are opened and how National deals with its customers, because I respectfully suggest that Attorney Perry's emphasis on the material supply contracts is wrong. Really, the contract at issue here is the credit agreement as approved and the open account, which allows his clients to buy materials on credit with an agreement to pay for them. And if the principal, F&M Realty Trust, doesn't, the guarantors, the principals of that entity, guarantee payment. So when a customer comes to National Lumber, they request credit. In this instance, they requested, I think, $150,000 of credit for lumber material and $50,000 of credit for windows. They made an application, they provided social security numbers and credit reports and the like, and they were approved. The record appendix shows a letter from National to the principals of F&M approving their request for credit. And when that happens, they need to be entered into National's system. They're assigned an account number for the lumber material that they purchase. They're assigned an account number for the windows that they may purchase. They presumably have a customer number as well, and then they're off and running. If they simply choose to buy materials without regard to any specific location or job, that's fine. We don't care. We simply supply them the material that they request and order. We deliver it wherever they tell us to. We have them sign delivery slips indicating receipt for the materials. We provide them with an invoice showing how much the materials cost. And every month we send them statements telling them what their account looks like in terms of purchases and payments and credits and how much they owe us. It's not uncommon for developers such as this to do one or multiple jobs. And when they do that, it makes sense to track different locations with different account numbers so that it's easier for us to track what we ship them and where. And it's easier for them to figure out what they ordered and for where. And for each job site, it's very common for a new account number to be supplied for lumber material and a new account number to be supplied for window material at different job sites. And the record appendix here, I think, reflects that that's what happened over the course of this relationship, some 10 years or so. I'm led to understand there were as many as 8 projects that this particular customer did. National Lumber supplied windows, they supplied building materials, they perhaps supplied specialty materials, and things were all fine until these 2 last projects went upside down and the account wasn't paid.
Excuse me.
It's also very common in this industry.
Judge Wolohojian trying to get in.
Sorry. Could we just look at the language of the guarantee?
Of course.
So I'm looking at the very first line, and it refers to the applicant on the reverse side hereof. Now, I didn't see any definition of the term applicant anywhere.
I think it presumes that the applicant is the company identified on page 1 as company business name.
A business name. Okay, so in the top box, there's F&M Realty Trust, and then I take it that was handwritten in on the two after that, right?
Correct.
And that was that handwritten in by the third co-defendant, fellow, I forget his name. That was handwritten by.
I don't have the correct pronunciation, Judge. I apologize, but I think it's Ritos.
Ritos, that's what I thought. Okay, and then
His
down.
name is also handwritten.
Yeah, and then down below, though, on the signature block, it says business name F&M Realty Trust without the 2. But does that make a difference?
Well, it's, again, I don't think it does, Your Honor. I believe that, salesmen, contractors are apt to use shorthand. The record here is replete with documents that use the 2, and it's replete with documents that don't use the 2. Okay. I think the understanding amongst the parties, if we're going to go beyond the 4 squares, is that there was one operating entity here. It was F&M 2.
If you look also at the guarantee, it uses the term customer with a capital C, which, oftentimes indicates that that's a defined term. But I don't see any definition for customer. Was there any definition for customer?
I do not believe that there is, Your Honor. I suspect that the assumption is that customer and applicant are interchangeable.
Well, then why would you use 2 different words?
Well, I'm not the author of the document. This is clearly a pre-printed form that National uses. And perhaps somebody who did draft it didn't pay sufficient attention.
Okay, so it's a form from National, and as the drafter, then if there's ambiguity, it would be construed against them?
I believe that's a fair statement of the law.
All right, so is it your position that the guarantee was ambiguous?
Oh, I don't think that's the case at all, Your Honor. I believe that the guarantee is very clear that the customer, applicant, or the principal, whatever you would like to call them, is the F&M Realty Trust 2 entity, and that the guarantors are the individual defendants as named in this action. It's very clear from the custom and practice of the industry, as well as the conduct of the parties.
Look at the custom and practice of the industry for an unambiguous contract. We're looking, if your position is that the contract is unambiguous, then we just look at the 4 corners of the contract. If you want us to look at course of conduct between these parties or the industry, I don't think we look there unless the contract has ambiguity.
Well, my primary argument would be there is no ambiguity. And if I were to be called upon to make a secondary argument, it would be the custom and practice of these parties clearly reflect what everybody intended.
Okay, so if it's unambiguous, an applicant and customer, and we were to accept that applicant and customer mean the same thing, and then we also accept that they both refer to F&M Realty Trust 2, why is it then that Attorney Perry is not correct, that the guarantee it's limited to the entity identified on the opposite side of the guarantee.
And thank you, Your Honor, because that allows me to go right back to my earlier presentation where I was talking about context of how these projects work. So after a customer is established, after account numbers are assigned, if that customer has multiple projects going at once, it's very common for developers to use single purpose entities to take title to those pieces of real estate and to get permits and to develop those parcels, all at the same time using their core entity, in this instance, F&M2, as the customer of National. And the reason we use material supply contracts for each individual job is to position National Lumber so that we can assert mechanics liens under Chapter 254. Now, Your Honors may be familiar with how that statute works, but in essence, we've got to do essentially three things to establish a lien against the property that's improved by the delivery of our materials. The first of which is we need to have a written contract enforceable by the laws of the Commonwealth that describes the material to be delivered to the entity that owns the property, because our mechanics lien follows one procedure if we deliver property to the property owner. It follows a different procedure if we deliver property to somebody other than the property owner. Those are general contracts and subcontracts. Chapter 254, Section 2 and Section 4 distinguish the procedures we need to follow in order to assert a mechanics lien. We then, within certain timeframes, need to assert a statement of account of record at the Registry of Deeds and ultimately start suit if we intend to assert our in rem rights against the property improved by the delivery materials. The material supply contract is the premise upon which we can assert a mechanics lien. We can't assert a mechanics lien against that property if all we have is a credit application approved. It doesn't meet the requirements of Chapter 254 in terms of specificity, and that's why we use material supply contracts.
Sure, but we're not really worried about that. You got the relief that you were seeking under the mechanics lien statute. We're worried here about the relief you're seeking in this suit, which is liability under the guarantee.
I agree, Your Honor, and the only reason I provide that information is to give context as to why material supply contracts were requested or signed. It was so that we could assert mechanics liens. The contract at issue in this lawsuit is the approved credit application and the approved guarantee. All of the material we sold to F&M Realty 2. All of the material that has not been paid for is owed by F&M Realty 2. And if F&M Realty 2 is a defunct realty trust that has no asset or ability to pay, then we have a right contractually to look to the guarantors of that account, which are the three individuals on the reverse side of the credit application.
So two questions on that. I'm looking at the material supply contract for 51 Pearl Street, which is trial exhibit SIT 4, I think. It's not with F&M Realty 2, it's with F&M Realty. And at the bottom, Mr. Crotty writes FIL as to say, I'm not signing for F&M Realty. What do we do with those two facts?
Well, I think there was an awful lot made of these questions at the trial below, Judge. And I think that's why two authority questions found their way onto the special verdict slip that the trial judge answered under Rule 20. There was an awful lot of discussion and briefing and argument on the questions of authority. And I think that the Rule 20 findings by the trial judge below speak volumes as to whether or not Mr. Crotty had authority to sign on behalf of F&M Realty 2. And she specifically ruled yes. I don't have those question numbers necessarily right at my fingertips, but there were two special verdict findings by the trial judge below, specifically finding actual or apparent authority by Mr. Crotty to sign these material supply contracts. Now, again, these were the contracts that were the premise of National's ability to assert mechanics liens. We sold these materials based on an approved open account. We sold these materials based upon the strength of that approved account, and we sold these materials based upon the strength of the personal guarantees. So we can't lose focus of what contract is really in dispute here. So with that context in mind, the defendants make essentially three arguments in their brief, and they've made three arguments below that there was reversible error here. Clearly, it's National's position that summary judgment was rightfully denied. A careful reading of the motion judge's memorandum of decision indicates that there were open material questions of fact that precluded.
Mr. Cacavaro,
Yes.
the issues on summary judgment were the same as the ones that were tried, correct?
I believe that they were, and I believe the case law suggests that if there's been a full trial on the merits,
You can't appeal the denial of summary judgment.
Exactly.
Right.
And there is some case law, Deerskin Trading Post case, I believe stands for that proposition, Judge.
That's correct.
And at trial, there was a full exploration on the factual questions and on the merits of whether or not this open account had been breached and if the guarantees should be enforced. I again believe that the Rule 20 findings by the trial judge speak volumes as to the sufficiency of the evidence presented to the trial court. And we can't lose sight of the fact that this was simply an Article 2 Uniform Commercial Code sale of goods. We had an open account. We shipped material as requested. It was received and accepted. There was no rejection. There was never any tender of or revocation of the personal guarantees. I believe the basic principles of Article 2 of the Uniform Commercial Code have been sufficiently met for purposes of establishing a good sold and delivered. And then lastly, the defendants argue that there was error in failure to involuntarily dismiss National's claims. We've cited some case law that supports our position that there was no intentional delay or neglect, and that the delays occasioned by the bankruptcy proceedings resulted in a significant hiatus, but not of our making. I can't let my last 30 seconds go without mentioning that this defendant executed a mortgage when we asked, "What's up with your account?" There was a meeting between the principal of National Lumber and Mr. Fleming, and the account was in arrears, some $250,000 or so. And he executed a mortgage ratifying, confirming those balances on behalf of F&M Realty 2. And that mortgage is in the record appendix. I can certainly provide a citation if you need me to.
Thank you. That's the $300,000 mortgage, right?
That's correct, Judge.
Okay. Thank you. Thank you both. We'll take this under advisement.
Thank you.